The Supreme Court of the United States just issued a ruling so sweeping, so absolute, so historically unprecedented that even the justices who disagreed with each other agreed on the outcome. 9-0, not 5-4, not 6-3, 9-0, and what they struck down wasn't some obscure technicality buried in federal code. They dismantled over a century of gun control architecture, permit systems, mandatory training, waiting periods, excessive fees, blanket sensitive place designations, all of it gone in a single ruling. This is the most significant Second Amendment decision since Heller in 2008, and the overwhelming majority of Americans have no idea what it actually means for their lives. Not the political spin, not the cable news panic, the actual legal on-the-ground reality of what this court just did and what happens next. If you've been following this channel, you know I don't do hysteria. I don't tell you the world is ending, and I don't tell you everything is fine. What I do is tell you the truth, even when it's complicated, even when it makes both sides of the political aisle uncomfortable. And right now, the truth is this: the legal landscape of gun ownership in America just shifted under everyone's feet. And the people who were supposed to prepare you for this moment were too busy screaming at each other to actually explain it. And so that's what we're doing today. If this is the kind of reporting you believe Americans deserve, factual, fearless, and without an agenda, then hit that subscribe button right now, because what's coming in the lower courts over the next 60 days is going to make this ruling look like the opening act. Let me take you back 2 years, because this ruling didn't come from nowhere. It came from a legal earthquake that started in 2022 when the Supreme Court handed down New York State Rifle and Pistol Association versus Bruen. That decision, also known as the Bruen ruling, fundamentally changed how courts are supposed to evaluate gun laws. Before Bruen, lower courts used something called a two-step balancing test. They'd ask whether a law burdened Second Amendment rights, and then they'd ask whether the government had a good enough reason to justify that burden. On paper, that sounds reasonable. In practice, it meant that almost any gun restriction could survive a legal challenge as long as the government offered some justification: public safety, crime reduction, community protection. The threshold was low. The bar was easy to clear, and for decades, state legislatures used that flexibility to pile restriction on top of restriction until the Second Amendment in states like New York, California, New Jersey. And Hawaii was barely recognizable as a constitutional right. Bruen changed the test entirely. It said that for a gun law to be constitutional, it must be consistent with the historical tradition of firearm regulation in America at the time the Second Amendment was ratified. That means 1791. That's the anchor point. Now, if the government wants to restrict your right to keep and bear arms, it has to point to a historical law from the founding era that did something relevantly similar. That standard sent shockwaves through every state capital in the country. Suddenly, laws that had stood for decades were vulnerable. Permit systems, carry restrictions, magazine limits, all of it had to survive a new and much more demanding test. But here's what happened next, and this is the part the media coverage almost entirely missed. The lower courts didn't know how to apply Bruen. Some judges demanded a historical twin, a law from 1791 that looked almost identical to the modern restriction being challenged. Other judges applied the test more loosely. The result was chaos, rulings going in opposite directions in different circuits. Gun owners in one state with rights that gun owners in another state didn't have, the law becoming a lottery based on which courthouse you walked into. That chaos is what made this new 9-0 ruling not just significant, but absolutely necessary. Because here's the thing about a 9-0 ruling that most commentators are breezing right past. In one of the most divided courts in modern American history, where 5-4 decisions are the norm, and justices can barely agree on the color of the sky. All 9 justices looked at this question and reached the same conclusion. That doesn't happen because the answer is complicated. That happens because the answer is obvious. The laws being challenged were so constitutionally indefensible that the justices couldn't find a single principled way to uphold them. Think about what that tells you about the laws that just died. Think about the audacity of state governments that looked at a clear constitutional right and spent decades engineering systems specifically designed to make that right inaccessible to ordinary people. And then think about the fact that those same governments are now standing in front of cameras expressing outrage that the court said no, that's not governance, that's theater. Now, let's get specific, because the devil is always in the details, and the details here are enormous. The first and most politically explosive thing this ruling killed is the may issue permitting system. For those who don't know what that means, let me explain it in plain terms. In states like New York and New Jersey, your constitutional right to carry a firearm for self-defense didn't actually belong to you. It belonged to a police chief, a judge, or a local official who got to decide, subjectively, personally, with almost no accountability, whether you had a good enough reason to exercise it. You could be a law-abiding citizen with a clean record, completed training courses, and a legitimate fear for your safety, and a bureaucrat could look at your application and simply write the word denied because they didn't think your reason was compelling enough. There was no appeal, there was no recourse. The constitutional right existed on paper and was withheld in practice. The Supreme Court in the Bruen ruling said that system was unconstitutional. But what happened? States like New York didn't dismantle the may issue system. They renamed it. They restructured it. They added new layers and new requirements and new categories of sensitive places. Where carry was banned, essentially rebuilding the same wall they'd just been told to tear down. This 9-0 ruling is the court saying, in language that cannot be misread or restructured around, we see what you're doing, and it stops now. The second pillar that is collapsed is mandatory training requirements. And I want to be precise here because this is where the nuance gets lost in translation. The Supreme Court did not say training is bad. The justices were explicit that firearms training is beneficial, that it promotes safe gun ownership, and that encouraging people to train is a worthy goal. What the court said is that the government cannot use training as a gatekeeping mechanism to prevent law-abiding citizens from exercising a constitutional right. There's a critical difference between those two things, and the states that built mandatory training requirements knew exactly which side of that line they were on. When a state requires you to complete a specific course that costs $500, is only offered at certified facilities in major cities, has a 6-month waiting list, and cannot be substituted with any other form of training, that state is not promoting safety. That state is creating a financial and logistical barrier that disproportionately impacts working class people, rural residents, and anyone who can't take time off work to spend a weekend in the city. The constitutional comparison the court drew was to a poll tax. You cannot charge someone for the right to vote. You cannot create a financial obstacle to the exercise of a fundamental right. And for the same reason, you cannot hide a financial obstacle inside a training requirement and pretend it's about safety. Those laws are gone now, and the states that enacted them should be asked, loudly and repeatedly, why they thought that was ever acceptable. Then there's the waiting period, and I want you to think carefully about this one because the emotional argument for waiting periods is genuinely strong and deserves to be engaged. Honestly, the idea behind the cooling off period, which is what waiting periods were originally called, minus was straightforward human psychology. If someone is in a moment of rage, grief, or crisis and they go to buy a gun, a mandatory waiting period of 3 days or 10 days might interrupt the impulse. It might save a life. As a matter of social intuition, that logic has real appeal. But here's what the Supreme Court looked at. The law doesn't apply to the person in crisis. The law applies to everyone equally without exception. A domestic violence survivor who has been threatened and needs immediate means of self-defense has to wait 10 days. A woman being stalked who reports the threat to police on a Monday can't complete her legal firearm purchase until the following Thursday. The law, designed to prevent tragedy, becomes, in those cases, a mechanism that enables it, and the court's ruling is that the government cannot justify that universal burden imposed on every single law-abiding purchaser based on the behavior of a small fraction of buyers. The historical record doesn't support it. The constitutional framework doesn't permit it. Waiting periods, in their current form, are unconstitutional. That is now settled law. The fee structures are next. And this is a conversation about class that nobody in the political mainstream wants to have, honestly. For years, states with restrictive gun laws charged application fees ranging from $50 to $200 or more. Just for the privilege of applying for a permit, you might be denied. That fee was non-refundable. You paid it, You waited months, and if a bureaucrat decided your need wasn't compelling enough, you got nothing back and had no right to reapply for a year. In some jurisdictions, the total cost of legally exercising your Second Amendment rights, permit fees, training fees, storage requirements, ammunition taxes ran into the thousands of dollars. And the people most likely to be priced out of that system were the people most likely to need self-defense, low-income residents of high-crime urban areas who couldn't afford the bureaucratic tax on their constitutional rights. Let's be honest about what that means. The progressive states that position themselves as champions of working-class Americans built a legal system where the wealthy could exercise their Second Amendment rights and the poor could not. That's not gun control. That's a two-tiered justice system with a constitutional veneer. The Supreme Court just said the fees must be nominal. And frankly, the question of why it took this long is one that deserves a genuine accounting. Before we go deeper into what states are doing right now to fight back, and they are fighting back aggressively, I need to make sure you understand the legal engine behind all of this, because it connects to a case that generated major headlines, but was widely misunderstood. United States versus Rahimi, decided in 2024, involved a man who was under a domestic violence restraining order and was found to be in possession of firearms. The court upheld the federal law banning gun possession by people under such orders, and immediately a lot of commentators on the pro-gun side said, "That's it, Bruen is dead." The court just backed down. That interpretation was wrong, and it has caused significant confusion ever since. What Rahimi actually did was teach the lower courts how to apply the Bruen historical test correctly. Before Rahimi, some judges were demanding a perfect historical twin, a law from 1791 that looked exactly like the modern law being challenged. Rahimi clarified that you don't need a twin, you need a historical analog, a founding-era law that addressed a relevantly similar problem in a relevantly similar way, but, and this is the part that matters, the government still has to actually prove that the analog exists. It can't just gesture vaguely at history and call it a day. In this new 9-0 ruling, the government tried to argue that old colonial-era bond requirements for dangerous persons were historical analogues for modern permit fees. The court rejected that argument flatly. The government tried to argue that 18th century militia training requirements were analogues for modern mandatory training classes. The court rejected that too, pointing out that militia training applied to all men in a community as a civic obligation, while modern training requirements apply specifically to individuals trying to exercise an individual right, a fundamentally different legal context. Rahimi didn't weaken Bruen. It sharpened it, and the states that thought they found a loophole discovered they were wrong. Now let's talk about what's happening on the ground right now. Because the legal battle didn't pause for this broadcast, within 48 hours of this ruling, federal lawsuits were filed in multiple jurisdictions challenging state laws that are now constitutionally suspect. In New York, the Concealed Carry Improvement Act, which was the state legislature's elaborate workaround after Bruen, designating nearly everywhere in the state as a sensitive location where carry was banned. 4 is facing a direct legal challenge. The provisions banning carry in Times Square, in subway stations, in places of worship, and in a long list of other locations are, under this new ruling, extremely difficult to defend. A preliminary injunction blocking enforcement of those provisions is not a remote possibility. It is a near certainty. In California, the Sensitive Places Law that banned concealed carry in 26 categories of locations, including parking lots and public libraries, is effectively a dead statute walking. Governor Newsom knows this. His response has been to pivot toward enhanced background check systems using state-level databases to go beyond the federal NISA system, which is a constitutionally defensible move. But it doesn't stop carry. It doesn't restore the permit barriers. It doesn't bring back the waiting period. Illinois, home to Chicago, one of the most gun-restricted cities in the country, is scrambling to figure out what municipal ordinances can survive this new legal reality. The answers they're finding are not encouraging for those who want aggressive gun control. In Hawaii and Maryland, attorneys general are already signaling a pivot toward ammunition regulation, microstamping requirements, and mandatory liability insurance for gun owners. These are the new frontiers of the gun control debate, and they reveal something important about the moment we're in. This is where I want to make sure you understand the full picture, because what I've described so far sounds like a total sweeping victory for gun rights advocates and a total defeat for those who believe in stricter regulation. But that's not actually the complete reality of what's happening. The states are pivoting. They are not surrendering. They are finding new ground to fight on, and some of that new ground is constitutionally defensible. The push for liability insurance for gun owners is clever because the court's historical analysis doesn't easily reach into insurance markets. The push for microstamping, requiring firearms to imprint a unique code on fired cartridges so they can be traced, is technically about the ammunition and the manufacturing process, not about the right to carry. Red flag laws, formerly known as extreme risk protection orders, are being aggressively expanded and are legally distinct from permit requirements because they operate on an individualized finding that a specific person poses a threat, rather than imposing a universal burden on all gun owners. And perhaps most interestingly, cities like San Francisco are exploring civil liability ordinances that don't ban guns in private businesses, but instead make businesses liable for any shooting that occurs on their premises if they allow concealed carry. That doesn't criminalize the gun. It creates a financial incentive for private businesses to ban it voluntarily. And because private businesses making their own decisions is not state action, the constitutional analysis gets much more complicated. The battle is not over. It has fundamentally changed shape. Let's step back for a moment and confront the larger philosophical question that this ruling forces onto the table, because it's one of the most genuinely difficult questions in American constitutional law, and it deserves to be engaged seriously rather than reduced to a bumper sticker. The dissenting opinions in this case, and there were 3 separate opinions written even though the vote was unanimous, on the narrow question raised arguments that are not easily dismissed. Justice Ketanji Brown Jackson, in her concurrence, acknowledged that the Bruen historical test has resulted in a 455% increase in Second Amendment challenges in the lower courts. She called the test, in her own words, unworkable. She was essentially admitting that the legal framework the Supreme Court itself created is generating chaos faster than the courts can manage it. That is a stunning admission. The justices who disagreed most forcefully with the practical implications of this ruling pointed to an undeniable reality. The Second Amendment was written for a nation of 3 million people, mostly rural, armed with single-shot muskets that took 30 seconds to reload. The weapons technology of 1791 and the weapons technology of 2026 are not comparable. The lethality is not comparable. The speed is not comparable. The scale of potential violence is not comparable. The argument that we should be bound in perpetuity to the regulatory framework of a pre-industrial nation in making decisions about semi-automatic handguns and high-capacity magazines is, to many thoughtful people, a form of historical paralysis, and those concerns deserve to be heard. They are not hysterical, they are not political, they are rooted in the reality of what gun violence does to American communities every single day. But the majority of the court, all 9 of them, remember, landed somewhere different. They landed on the principle that a constitutional right cannot be subjected to a cost-benefit analysis, that if the Second Amendment means something, it has to mean something in practice, not just on paper. That a right which can be regulated into practical non-existence through fees, permits, training requirements, and sensitive place designations is not actually a right at all. It is a privilege extended at the discretion of the government. And the Constitution's entire purpose was to define the things the government does not get to have discretion over. Whether you agree with that conclusion or not, it is a coherent legal argument. And the fact that 9 justices with wildly different judicial philosophies all arrived at the same result should tell you something about the strength of the underlying constitutional logic. Now let's talk about what the next 6 to 12 months actually look like, because that's what affects you. The immediate impact will be felt most sharply in the states that built the most elaborate permit systems: New York, New Jersey, California, Hawaii, Maryland, Illinois. These are the states where the legal whiplash will be most severe. Emergency legislative sessions are coming. Attorneys general are going to push injunctions to delay implementation. of the ruling, while new laws are drafted, courts are going to be inundated with Second Amendment challenges that were previously considered long shots. And the reciprocity question is going to come roaring back to the center of federal legislative debate. The Constitutional Concealed Carry Reciprocity Act, which would require every state to recognize every other state's carry permits, has been floating in Congress for years. This ruling doesn't make it redundant, but it does change the dynamic significantly. If every state's permitting system has to meet the same constitutional floor, the argument for forcing reciprocity becomes simultaneously easier and more complicated. Easier because the disparity between state standards is now legally constrained. More complicated because the states that opposed reciprocity can no longer argue that their higher standards justified their refusal to recognize other states' permits. The legal floor is the same now, and the Wohlforth versus Lopez case waiting at the Ninth Circuit, which involves Hawaii's attempt to ban carry on all private property without the owner's express permission, is almost certainly heading to the Supreme Court, and almost certainly getting reversed in light of this ruling. That's the next domino. Watch for it. What I need you to understand, what the headline chasers and the outrage merchants on both sides are not telling you, is that this ruling is not the end of gun regulation in America. It is not the end of background checks. It is not the end of laws that keep guns out of the hands of violent criminals, domestic abusers, or people adjudicated as dangerously mentally ill. The Rahimi framework explicitly preserved those tools. What it ended is the use of bureaucratic architecture, fees, permits, training mandates, waiting periods as a shadow system for denying a constitutional right to people who are legally entitled to exercise it. There's a real difference between those two things, and the quality of our public conversation about gun policy depends on whether we can hold that distinction clearly in our minds rather than collapsing everything into a binary of pro-gun or anti-gun. The question going forward is whether states will channel their regulatory energy toward constitutionally sound interventions, better background check systems, red flag laws with robust due process protections, investment in community violence intervention programs, or whether they'll burn time and resources fighting battles they've already lost in court. The early signals are mixed, and that's what we'll be watching. There's one more thing I need to say before we close, and it's about the criminology, because I know that's what a lot of people are waiting for. Does this ruling mean more gun violence? Does it mean less? The honest answer, the truthful answer, the answer that doesn't try to sell you a predetermined conclusion, is that we don't know yet. The research on right-to-carry laws and their effects on crime rates is genuinely contested. There are credible studies suggesting that broader carry rights correlate with reductions in certain types of violent crime because criminals adjust their behavior when they can't predict who is armed. There are also credible studies suggesting that the presence of more firearms in more public spaces correlates with increases in aggravated assaults and incidents where arguments escalate fatally because a weapon was within reach. Both sets of findings exist in the peer-reviewed literature. Neither should be dismissed. The data on the specific impact of this ruling won't exist for 3 to 5 years. Anyone telling you with certainty what it will produce is either lying to you or has no idea what they're talking about. What we can say is that the effects will not be uniform. They will vary by city, by neighborhood, by socioeconomic context, and by the degree to which states invest in the constitutional alternatives to permit-based regulation. This is not a simple story. It never was. Here's where we are. The Supreme Court, in a unanimous ruling that transcends partisan lines and reflects a genuine legal consensus, has dismantled the 5 pillars of restrictive gun control that governed American law for over a century. May issue permits are gone. Mandatory training as a prerequisite for ownership is gone. Waiting periods are constitutionally invalidated. Excessive fees are prohibited. Blanket sensitive place designations are struck down. Every state in this country is currently in some degree of non-compliance with this ruling, and the scramble to adapt is underway right now, today, in legislatures and courthouses from New York to Honolulu. The battle is not over. It has moved to a new terrain: insurance mandates, red flag expansion, liability ordinances, ammunition regulation, and it will be fought there with the same intensity and the same stakes. The people who told you this was a settled question were wrong. The people who tell you the answer is simple are wrong. This is a constitutional reckoning that is going to reshape American law for the next generation, and it demands the kind of serious, sustained attention that most media institutions are not willing to give it because serious attention doesn't get clicks the way panic does. If you want the kind of reporting that actually prepares you for what's coming, not the spin, not the outrage, but the facts laid out with the context they require, then subscribe to this channel right now and hit the bell notification. We are tracking every lawsuit, every emergency legislative session, and every court order that comes out of this ruling in real time. The lower court chaos is just beginning. The legal battles that are going to define your rights over the next decade are being fought right now, and I am going to be here every step of the way, making sure you understand exactly what's happening, why it matters, and what it means for your life. This is not the end of the Second Amendment wars. This is the first true test of the Bruen framework without any guardrails. And the America that comes out the other side is going to look fundamentally different from the one that went in. Be informed, stay engaged, and hold your elected officials to account, because when they fail to protect your rights or when they fail to protect your community, that failure lands on your doorstep, not theirs.